If you're with us for another round, we thank you so much for listening. Unilateral Decisions has one more episode as we delve into the concept of just how we got to today's current college athletics landscape. For this episode, we're jumping ahead to the case of Alston versus the NCAA in 2021, which really set the precedent that the NCAA could no longer operate like they had in the past, and that led to an awful lot more. So our duo of former college administrators Nickell and Mike Walsh talked with sports legal expert and college professor Sam Ehrlich to put a bow on just how we got to today. Hey everyone, welcome to another episode of Unilateral Decisions. I'm Dominic Shelden alongside Mike Walsh, Sam Ehrlich, Nickell. And Sam, since you're the legal expert here, we're talking Alston versus the NCAA, a 2021 ruling, but elevator pitch as fast as you can. Basics, what the heck was this case about?
Well, surface level, it was a very narrow kind of challenge and a very narrow kind of really decision to a certain extent. It was about restrictive caps on education-based compensation. So things like paid internships after you leave college, whether schools can promise that to their athletes, or computers, or a variety of different things like that, where, they're very much tailored to education-based compensation. We're not in NIL, contrary to a lot of people, including members of Congress, seem to think. Alston did not grant NIL rights. It's all kind of this education-based compensation. But, do have to say a little bit more than that, because Alston really, because it was the first of these cases to be taken by the Supreme Court since Board of Regents, it was the first one that really looked at the amount of deference that the NCAA has under antitrust law, and really challenged the idea about whether the NCAA, through its amateurism mission, should have antitrust immunity.
Last episode, we talked about O'Bannon versus the NCAA about 5-6 years prior. How did that O'Bannon case set the stage for Alston?
So one thing to keep in mind, and I think this really does set the stage here, the Supreme Court obviously, and I think this is obvious just by, we mentioned about the O'Bannon lawsuit, they didn't take the NCAA nor the plaintiffs' appeals of O'Bannon. The Supreme Court has no obligation to take a case. They only take cases that are particularly important for a variety of different reasons. And one reason is if there's what we call a circuit split. A circuit split meaning the Ninth Circuit Court of Appeals, which is based in California, Idaho, Washington, Arizona, Oregon, the West Coast. If they issue a decision that is different, that really kind of analyzes the law differently than the Third Circuit Court of Appeals, which is Pennsylvania, that kind of area, New Jersey. If they differ, then the Supreme Court might want to step in. If they feel like they have to, they might want to step in and say, okay, you two circuits disagree. We need a consistent law across the country. This is how we're going to interpret it. We're going to side with the Third Circuit. We're going to side with the Ninth Circuit. We're going to develop our own rule. And the O'Bannon lawsuit led to the Supreme Court taking the case, I think, in a big way. Alston did as well, because it established a circuit split. It established a major rift in how these federal courts of appeals were analyzing these amateurism-based antitrust lawsuits against the NCAA, where we had the Ninth Circuit and O'Bannon being very kind of undeferential to the NCAA. They said, there has to go through full rule of reason. We're going to acknowledge amateurism as a pro-competitive justification, but we're going to still require you to prove that it counterbalances the anti-competitive harms, and that there's no less restrictive way of doing it along stage 3 of rule of reason. And the NCAA was furious about this, not just because they lost, but also in a big way, because this went against what the Third Circuit, Sixth Circuit, and Seventh Circuit had established in terms of how they're looking at these rules and how they're looking at amateurism and antitrust challenges to amateurism, where the Seventh Circuit Court of Appeals had said, as recently as 2012 in the Agnew case, and 2018 in the Depp v. NCAA case, they had said, because of Board of Regents, because of this ample latitude that the Supreme Court prescribed for the NCAA in Board of Regents, we are going to consider amateurism to be a pro-competitive presumption, where any rule kind of related to amateurism is presumed to be pro-competitive, presumed to comply with antitrust law. And while it wasn't a full exemption from the NCAA, it was, I field colleagues who've written an article referring to that as a quasi exemption. I agree with that. It was basically an exemption from antitrust law, without getting into on the motion to dismiss instead of going into a full trial, and significantly more deference for the NCAA. So we had, and that doesn't even get into what the Third Circuit and the Sixth Circuit we're talking about, which was even more deference to the NCAA. But clearly, the NCAA was very, they felt like they really needed guidance from the Supreme Court as to how these rules are going to be interpreted under antitrust law.
Correct me if I'm wrong, but we talked about O'Bannon, we're talking about Alston. Like, this is all important because the NCAA is trying to maintain its status as, an amateur sports endeavor.
Correct.
And their belief is that if they lose that amateurism, tilt, that they become minor leagues and people are going to stop caring and stop paying attention. And so that, for the NCAA, that's what all of these lawsuits are about.
Yeah, essentially. And I think, it's become very clear from the past 5 years, antitrust law, like this exemption from antitrust law, was really keeping the NCAA's amateurism rules afloat, because it was something where, and I think it also is kind of impactful. Again, Alston didn't directly lead to NIL, but the timing was exactly correct.
Yeah, how many days was it after
10?
Yeah,
it was 10 days
after the Alston decision.
It was 10 days because we had all the state legislation starting with the California Fair Pay to Play Act, and which was passed in 2019, and just accelerating from there. Florida, Colorado, Nebraska, all these states that kind of copied the California, the California model, except that California had put their start date at 2023, July 1st, 2023. I think it was Florida that started saying, oh no, we're going to start this at July 1st, 2021.
Yeah.
And that accelerated the timeline. And Alston was issued on June 21st, 2021. And the state laws came into effect on July 1st, 2021. Not a lot of time for the NCAA to adapt. And to your point, the NCAA, I think what a lot of people kind of forget about that time period, the NCAA had been starting, they saw the writing on the wall. They had been starting to create their own NIL policy that sought to preserve guardrails and sought to do a lot of these things. And that got to the point where it was about, I want to say January, February of 2021, they were all set to kind of unveil it. And then they got a letter from the Department of Justice, the Antitrust Division of the Department of Justice, saying, hey, those rules that you're contemplating for NIL, they probably violate antitrust law. Yeah. So the NCAA said, let's pare this back. Let's see how this Alston decision goes, because that's right around when the Supreme Court granted certiorari to Alston. Let's see how this goes. And, we're the NCAA. We're going to win this case. That didn't happen.
No. Yeah, to your point, everybody knew this was coming. I mean, I remember Walsh and I working on architecting our NIL program. It was a COVID passion project. Everybody knew it was coming, but you're sitting there trying to figure out what the rules are going to be, what the parameters are going to be, and so you've got all these different models of things you can do, and then all the guardrails seemingly came off, which was kind of unexpected.
Yeah, we had built something out in April of 2020, and we had all these contingency plans, and the preliminary stuff you're talking about was kind of leaked, and we'd all kind of seen what it was, and we thought, okay, well, here's one way, and June 23rd, we were like, I don't think any of that matters. So we're just gonna, this option we had that was like the fullest extent of institutional involvement, we're gonna choose that one. We're gonna run with it.
Yeah, so essentially the NCAA had to scrap their policy that they had spent months developing in favor of a policy that they had 10 days to develop. Generally does not yield success. And what the NCAA's policy to that end ended up being was incredibly laissez-faire, because it had to be, because they had absolutely no way of determining what was going to be legal or not, because the full effects of Alston had not come yet to pass.
One of the things that I found fascinating about the Alston case is they like you mentioned, it's all centered around costs or expenses related to education. Mm-hmm. And one of the examples they give is kind of the boogeyman is Nike has an intern that they pay $500,000 a semester to be an intern for Nike. It's funny to me that was such a concern. And now we've got quarterbacks making multi-millions of dollars every year for not even attempting an internship.
Free market.
So what was the big concern from the NCAA with Alston? And then looking at it now, did it matter?
their big concern is exactly what happened in O'Bannon, where the Ninth Circuit had really disrupted their legal position, their legal footing, because for one, it is incredibly expensive to go through rule of reason. It's incredibly risky to go through rule of reason because that's all a balancing act. It's all very subjective. It's all based on how the court determines how strong the pro-competitive justifications are, how strong the anti-competitive exemptions are, and how feasible kind of the plaintiffs offered kind of solutions to meet those pro-competitive justifications actually is. They loved having the Seventh Circuit, the Third Circuit, and the Sixth Circuit rule that essentially dismissed these lawsuits just based on the pleadings at the motion to dismiss stage. It was a lot cheaper, a lot more predictable, and just gave them a lot more legal security and a lot more legal power. So they were really worried about the ramifications of not just O'Bannon but Alston when it came out, and the Ninth Circuit continued to be very skeptical of the idea of granting the NCAA this deference. There's even a concurrence in the Ninth Circuit Alston opinion that even said, hey, majority opinion that went in favor of the players in this case. You didn't go far enough in favor of the players in this case. Judge Milan Smith, had this concurrence saying, why are we even considering kind of consumer preference in this antitrust equation? We should be looking strictly at, what are the effects on this particular market? And the NCAA was justifiably terrified of that. So they appealed to the Supreme Court. They assumed that the Supreme Court would go back to Board of Regents, and they lost 9-0.
Yeah, I think that unanimous decision, we haven't really kind of recapped like Alston, what it was, but then also a 9-0 unanimous decision to what you said in your eyes, in the NCAA's eyes, change course from previous Supreme Court. Which was, Regents was 7-2. We talked about that in the first episode. There was a dissent there. There was reason to think, hey, like there's some precedent that the Supreme Court level is going to see things our way. And it not only went the other way, it flipped, so hard as possible. And it was almost like 9-0 with an asterisk because of this concurrence from Kavanaugh that, everybody, like we'll dive into that here in a second, but it has become not only the decision, it was like the magnitude at which this was a 9-0 decision has really ramped up the things that we've seen over the last few years, where yes, Alston was about educationally related benefits and how that could be divided and how athletes could have access to those. And that was decided, very, very clearly, but then the language around it, the narrative of the concurrence, it took it very quickly to say, okay, this is about more than just educationally related benefits. This is about what the NCAA can actually stand in the way of, what they can make rules around. And, I guess to that point, Kavanaugh's concurrence, Joe, I know we've talked kind of off camera about the way that in hindsight, even like reading it now and what that looks like compared to how you were in the chair when you're thinking about it through the NCAA's lens. You've been at the college level for a really long time at that point and operating in that way. And now given not only like what we've seen change, but also the hindsight to look back and say, and like your reaction to that concurrence.
Yeah. It was, you said 9-0 with an asterisk, and that asterisk was like, we think you should challenge more and you're going to win. Which is, that kind of leads me to my question. I say this probably every episode. I literally don't know the answer to this question. Like Kavanaugh seemingly welcomed more and, intimated that you're going to win if you keep challenging. So what does the NCAA do right now to start rewriting the rules and getting to a point where we know now, going back, we know what the finances are, we know where we're going to lose, we know what the public opinion thinks. Like, what does the NCAA do right now to rewrite this fresh, clean slate, so they're not going back to court seemingly every day and getting things challenged and stripped away? And I guess my question is, at what point, and maybe they already are, and this is the part I don't know, do they get proactive versus reactive?
Yeah, I remember that day, that June 21st, 2021 day very, very clearly, because there's just so many conversations around this. And I immediately started writing an article, or several articles on this, because it was just so impactful. And I remember the reaction to it. I remember a lot of really smart people, and I think justifiably so to a certain extent, saying, Well, it's a very narrow decision. It's only related to this injunction. It's only related to this education, but these education related benefits. The NCAA issued a statement saying it's a narrow opinion. It only relates to education related benefits. And I remember reading the case and thinking, no, this is going to be a lot broader, because it goes back to that circuit split. It goes back to, the Third Circuit, Sixth Circuit, Seventh Circuit had this deference for the NCAA. The Ninth Circuit didn't. Not only did the Supreme Court side with the Ninth Circuit, they did so. They probably even went past what the Ninth Circuit said. Because the Ninth Circuit's still, going back to O'Bannon, they overturned the $5,000 trust fund that Judge Wilkin had ordered as part of the injunction because it didn't defer to amateurism as much. Supreme Court, and this is the majority, not even the Kavanaugh concurrence, really continue to kind of question how much that can continue to stand up. So I know that's a very long way to get to your question, Joe, but answer your question. I'm not even sure. From a policymaking perspective, I don't know how you can necessarily be proactive about it, because courts move slowly, and we're now in 2026, and it's been 5 years since Alston. I don't think we still have a really firm idea of where this is going, of the impacts of Alston. I mean, my dissertation was on looking at the 37-year impact of Board of Regents, and that evolved over time. But Alston, as we're seeing, I mean, the impacts are continuing to be felt. In these eligibility lawsuits, for example, we still have a number of courts disagreeing over each other about how much Alston kind of impacted the game, how much it changed the game. Some courts are still citing pre-Alston precedent. Some courts are saying, no, it's a completely different environment here. And I think from a policymaking perspective, it's really difficult to actually step in and say, here's what we need to do, because we still don't know what the courts are going to rule. We still don't know how the courts are going to treat what the legal landscape of college sports and antitrust law is after Alston, even 5 years after Alston.
So this is just going to continue lawsuit, and whatever those, results are from the lawsuits, that's going to continue to define what the future of college athletics looks like.
Unless we have collective bargaining or a congressional exemption, that looks like to be the case.
Okay, so collective bargaining, that's what everybody talks about. We're not going to get anywhere until we get to collective bargaining.
We might need a full episode on collective bargaining.
Literally, what is the first step? How do you? I know there's entities out there right now that are trying to seemingly assert themselves as the group that's going to represent college athletics.
Kavanaugh talked about it in his concurrence. Collective bargaining might be the way you need to go.
So what is step one? And when can we do that?
Again, we might need a whole episode on collective bargaining, but that's a really good question, because I think step one is convincing athletes that they actually want collective bargaining. Because if you're a power two football player right now, why would you want to collectively bargain? Why would you want to have a antitrust exemption right now? Why would you want to unionize and kind of strip yourselves of the ability to do what Joey Aguilar did, for example, and file an antitrust lawsuit? Or I think it was antitrust. I'm actually haven't seen that complaint yet. So maybe Aguilar is the wrong example. Diego Pavia, going back to the source, file an antitrust lawsuit to be able to get an extra year of eligibility. That would not exist if there was a collective bargaining agreement that limited the amount of eligibility that you can have, that defined JUCO years as counted the same as Division I years. That court decision would not have happened, because it would have been exempted from, under the non-statutory labor exemption. So I think that's step one, and that's a pretty monumental task right there.
Feels like a leveraged conversation.
It does.
It's shifting where, you brought it up, but athletes.org, to name them, they've done a lot of the work to try to organize, to try to, share that message. But I do think even in the time since they have started and they've done a lot of groundwork, the leverage has shifted to the point that we are seeing all these eligibility lawsuits. We're seeing all these things. It's not a matter of, maybe the NCAA could have curtailed some of that by 4 years ago, walking out and saying, all right, let's get to the table and let's start talking. But to your point, the athletes weren't organized. It would not have been very easy. And now, in the time that the athletes have worked toward organizing, the athletes actually have so much leverage in that the NCAA is the one who wants to come to the table now. And there's enough athletes who are going, well, I'd like to make my own rules, I think.
Well, I think it's also part of the problem. The NCAA itself is still adamantly opposed to collective bargaining. Sure. We have people within the NCAA who are kind of starting to support it, and those cracks are definitely starting to show. But yeah, going back to Alston, going back to our discussion of Alston, I think one of the biggest impact Alston had is because it changed the landscape of antitrust litigation against the NCAA so drastically and made it so much easier to actually file and win antitrust lawsuits against the NCAA. It's a leverage thing. It's not even necessarily a legal thing. It's exactly what you said, Mike. It's a leverage thing where, like, looking at the history of collective bargaining in sports, it's kind of this unique kind of environment because, collective bargaining agreements in a lot of ways set up these competitive balance restraints that sports leagues really feel like they need. And I mean, I feel like it's me trying to distance myself. I also agree that that competitive balance is generally a good thing. I'm a San Diego Padres fan, so especially attuned to that in 2026. But like you look at go back to 1993, for example. Forget 1993. Go back to 2015 when you had the most recent labor dispute between the NFL and the NFLPA. What did the NFLPA do? They decertified as a union. They said, we don't want to be a union anymore because we want to file a lawsuit for antitrust. That's what we're talking about here, except we don't have the pesky fact that they were a union before. And that's why, it's a labor dispute, and therefore the labor law still applies. We don't have a union in college sports, so there's nothing tying them to, kind of having this antitrust immunity, to having kind of all the protections that labor law grants to, collective bargaining agreements and grants to, and really pushes courts to stay out of these labor disputes. We don't have any of that here, so it's really kind of open season.
Take me back for Joe and Mike on the administration side. You're in college athletics when Alston happens, and you read a scathing review from Justice Kavanaugh that essentially says the NCAA is not above the law, and its business model of using unpaid labor to generate billions raises serious questions, which I think is fair. That led into every college athletic department probably knowing that more people are going to challenge the NCAA. They don't have as strong a legal footing as they once did. So what are the conversations taking place at a time where you don't know the future of college athletics? You don't know the future of the NCAA. Many of you are working from home, or if you're in the office, you're getting tested for COVID 3 times a week. So how weird was that time? And what are the discussions? How are schools across the country trying to plan, not only for what makes sense for your university, but knowing that each state might handle things a little differently as well?
I think the last part of what you said hits a lot of it for me. It was almost like an emperor has no clothes moment, where for years, you go back to O'Bannon. I mean, I remember I was a student at the late 2000s in Washington State working in the sports information office, and you knew O'Bannon was coming. Like, we knew that something was going to change even back then, but you were always looking to the NCAA and saying, okay, well, how are we going to change? How are we going to adapt? Are we not going to adapt? What is that going to look like? What is this industry going to look like? Alston happens, and I think it became very obvious very quickly that it was no longer the NCAA that was going to really decide, and you weren't looking to them for the guidance. I think you were holding on to that hope for a little bit to say, like, well, maybe they knew this was coming and they've got it figured out and they're gonna show us and tell us. But pretty quickly it became clear that not only did they lose some of the power, so like they couldn't even really step up and be the voice in the room. There just wasn't a whole lot of voices in the room, and then it became state fractured, and it became everybody out for themselves to a certain degree. How could you convince your local legislatures to do something that was going to benefit you and not the other person? And it very quickly became all, everybody for themselves kind of. And so it was very different. And the term, the Wild Wild West term, gets used, way overused in the NIL sense. But from an administrative sense, that happened like that with Alston, where it became up to each school, each state. You might try to get your state, fellow state school partner, but if you're private versus public, there's all these different things. And it really very quickly became every man for themselves. And I don't know if you felt the same way, but that was, I think, really the lasting impact of Alston that we still feel today, is that it was no longer, okay, how can we as the NCAA's membership make sure that we're moving forward? It was like, well, how am I going to get mine? How am I going to make this work for me?
Yeah, it's kind of funny, just jumping in before Joe gives his thoughts on this. It's kind of funny because Idaho, for example, ended up being in a pretty opportune spot when it comes to state NIL laws because they didn't have one. And they still don't have one. Because, all these state laws, going back to the Fair Play to Play Act in California and all these other, they had restrictions that I think were anticipatory of what the NCAA was going to do. Mm-hmm. Really what the universities wanted to do. That suddenly shifted as soon as Alston happened because now there were no rules. Mm-hmm. Now the NCAA, was going to have to leave it to state legislatures before they kind of, regrouped and tried to figure out something on their own, which they still really kind of haven't. Al Settlement does some of that. But like having no rules was suddenly better than having rules.
This is a very common talking point.
Yeah, 100%. Yeah, I remember working on stuff and then seeing things come through and like, oh, you have that in place, and now you've put your schools at a disadvantage, even though you were trying to give them an advantage. And I mean, Mike said it. Every man for themselves is kind of what it felt like. I remember having conversations with other entities trying to help them position themselves for what was to come. Like, it makes sense for you to be involved in this, and let's do this together. And it's like, we're not touching this because we don't know. And it's like, I feel like they're a little behind the eight ball now after.
Yeah, I think, that's a whole episode too. Yeah. And I think we'll probably get to that. But yes, the point about, we had many conversations with many, to your point, smart people. And it's like, really think not having a law is helpful here. And you're looking at Texas and you're looking at these other places that have put something in place that really were more restrictive than what the NCAA ultimately could put on the table after the Alston decision. Everybody was trying to be ahead of it and predict what was going to, best position themselves. And all of a sudden there were no laws, there were no rules. It was very clear through Kavanaugh and everybody else that kind of figure it out as you go. And so not having the laws in place, yes, it made it very chaotic, but it also, you kind of got to start fresh, which frankly was kind of a fun thing. And that's where, the NCAA just not really having the teeth anymore, I think made it to where the states were on their own, the schools were on their own, the conferences tried, but now you've got, interstate kind of situations where you're trying to find the lowest common denominator, but nobody wants to be part of the lowest common denominator. And so ultimately it was like, well, how can we help ourselves? And it was, to your question, it was just a monumental change from how previous, rulings either for or against the NCAA would dictate how to administer college sports, because it was always, how do we follow the NCAA's lead here? How do we help maybe, convey to the NCAA through different channels that this would be good? And you try to be a part of the solution together. At this point, there was no together as far as being part of the solution. I think that's part of why we see the chaos even today. But back to the conversation you guys were having earlier about where that gets solved. If it's going to keep getting solved in court, which we're kind of on that track, and I don't really know how you get off of it right now, it's not going to go back to, kind of everybody figuring it out together, because now all of a sudden, are you colluding? Are you price fixing? Are you doing all these things? It's kind of got to play out. And so the people who are most ahead of it, trying to be, most advantageous and being true to who they are and what their mission is. And that's where I go back to the education conversation and all the different things where just try to be who you are, try to be defensible, try not to, try to be smarter than the next person. Just be who you are, be who you say you're going to be, deliver the value you say you're going to deliver. And when it gets challenged, truth is the best defense. And so trying to be who you want to be and set it up the way for you to set it up. And I think we often get caught up in the competitive nature of college sports, which makes sense, but I think the short-sightedness of trying to win the next game or the next argument has led us to a lot of the places that we're at right now, instead of taking the longer-term approach and the bigger picture view of saying, what's defensible? How do we move forward? Who do we want to be? And I think the schools that are doing that, the conferences that are doing that, the states that are doing that are at the advantageous position of saying, we're going to take this as it comes. We're not going to be worried about every tiny little minute challenge because we're trying to get the littlest advantage we can. And it may, that may help them win some games and some CFP games and March Madness games for the next couple of years. But I think that the longer term approach is what's going to help everybody in the ecosystem.
I think at the end of the day, as we distilled down Alston, to me, it really shows that the NCAA no longer is the unilateral decision maker across college athletics. Pause for applause. Great callback.
Roll credits.
So with that in mind, we move into our unilateral decision. Who should be responsible for defining the structure of college sports today?
I guess I'll just keep going off where I was headed there. I do think it needs to consolidate a bit. I don't want it to be school-based. I don't want it to be state-based. I think that conferences have a ton of power and are in position to take a ton of the power. All the way back to regions. I mean, we've talked about this in episode 1, but it moved to the conferences because it was decentralized from the NCAA for the revenue component, the TV revenue. And I think that has continued, and I think that's a natural place for it to go. I also think that, as we discussed in the first episode about how college football's postseason is separate from the NCAA, I think that the CFP has a seat at this table to try to figure out what does the future look like, how do we organize, how do we structure. And I think, we've all talked around collective bargaining. Clearly, there's going to be episodes in the future about collective bargaining for us to really dive into. But that part of the first question is, who do the athletes bargain with, right? If the athletes are going to be negotiating, who are they bargaining with? And I think that's, the point here. If I'm lording over college sports, you do have to, I think, fracture it. I think that football is different. I think whether or not men's and women's basketball is different remains to be seen. But I think it's pretty clear at this point that football is different. And I also think that football has a different structure to where you can take advantage of that. And, I think that the CFP, whether that's through delegation by the conferences that really run CFP, I think that becomes an entity, and it can become an entity, and I would push for that if I were trying to direct how this was headed. But you are going to have to bargain, you are going to have to negotiate, and therefore there's going to be more people involved. It's going to be hard to say, hey, from an authoritarian position, this is how it's going to be. I think by the nature of where this is headed. But I think the CFP and I think the conferences, and sometimes that's the same thing because of the conference's involvement with the CFP. But I think that they set really the economic structure of how things look, which is what so much of what is going to want to be negotiated. And then I still think there's a place for the NCAA from a governance standpoint, from an eligibility standpoint, to really kind of set the rules around, like, what are the table stakes of being able to get in? How do you know that you are a college athlete? How do you know that you're eligible to be at this level? So I think it bifurcates a little bit where you've got kind of the standards that are set by a governing body, which right now is the NCAA, and I think still can be despite all of the legal ramifications. And I think that the conferences and or the CFP who own the economic value right now have to be the ones that are negotiated with from a revenue economic standpoint.
So I'm going to take an unpopular position in terms of your unilateral decisions in terms of like who should be the one kind of governing college sports. I'm fine with the courts doing it. And I know that's probably something where, and right now, especially with the impact of the Charles Bediako decision, I think is the one that's raising a lot of firestorm right now about, this judge with, all of his ties to University of Alabama, allowing a University of Alabama basketball player to enter into the league despite playing in professional sports. Like, a lot of justifiable anger about that. But I do think at a certain point, we're going to get to an inflection point where we're going to be able to figure out what rules work and what rules don't. I am an antitrust purist. I believe strongly in antitrust. I think that monopolies and cartels are, and maybe this is a strong opinion. I think that monopolies and cartels are bad. Shout out fanatics. We were having conversations about that offline or off camera.
We'll bring those on camera soon. Don't worry.
But I think to a certain extent, we need to let antitrust law do its job. And antitrust law is not, like, there's nothing in the Sherman Act that says that the NCAA is illegal. The Sherman Act bars, or Section 1 of the Sherman Act at least, bars contracts, combinations, or conspiracies to unreasonably restrain trade. And that unreasonably word carries a lot of weight. And I think we're already starting to see it in the federal courts. I mean, the state courts for these eligibility rules are a lot more inconsistent, and maybe I could see some argument there that needs to be cleaned up. But in the federal courts, we're already seeing some, kind of coalition, some kind of coalescing in terms of what exactly eligibility rules are going to be defensible, what they are, and what standard you need to have to challenge these eligibility rules. And eventually we're going to get to a point where we're going to get a decision on the merits from a court of appeals that actually says whether or not these rules are anti-competitive or not, and how powerful the pro-competitive justifications are. And maybe it'll take a few years, but we will get some kind of balance where we find that, okay, well, maybe the NCAA needs to do better about, having more meaningful waivers, as Judge Connolly in the Furkurian case said. How about having meaningful exemptions and a meaningful waiver process? Maybe they need to get to a point where they have neutral arbitration over waiver claims instead of having NCAA people kind of decide these things and being very inconsistent about the way that these cases are decided. Maybe there needs to be some kind of precedent system where maybe it's not the courts necessarily handling all the waivers, but some kind of system where it's actually accountable, it's actually trackable, it's actually something where maybe the player can actually file a challenge instead of relying on the school to file a challenge for them. There needs to be a better way of doing this. I think reflexively saying, well, the NCAA needs to have eligibility rules, that's fine. I agree with that. But that doesn't mean that the NCAA's way of doing eligibility right now is reasonable. And I think there's a lot of ways that the NCAA can better position some of these rules and do so without collective bargaining, without interference, or without congressional intervention in a way that does comply with antitrust law. And it'll take some time. It'll take some legal fees, and maybe you need to have some of it at least covered by congressional mandate. But I think let the courts do their job is not the worst approach overall, but maybe, I'm sure that is a very unpopular opinion.
Yeah, but bold of the lawyer in the room to think lawyers need more power.
Shocking, right?
Color me surprised. Joe, finishes off here.
The problem for me with letting the courts decide is that it's going to take too long. And
True.
Every new, ruling is going to move the goalposts and open up new lawsuits. Like, you talked about several things that need to be fixed, and like eligibility. Like, we know what all the problems are. Like, we know what they are today. We know, I'm not smart enough to know what is antitrust, what's not, but the lawyers do. So we know that, or at least we believe, the end of this line is going to result in collective bargaining. So
Probably.
So you have one side is going to be, NCAA/administration. You have the other side that is going to be student athletes. You know that there is going to be bargaining. Take the smartest people on the NCAA side of things, put them in a room for a year. You guys know what the problems are. Come up with something that is addressing all of these problems, keeping student athletes in mind. You have a year or whatever it is on this side to bring the smartest people on this side of the table with presenting their ideas. Come together. Let's agree on what this looks like. Brand it, like you talked about last episode. Brand this as college sports, whether we want to talk about amateurism or not. Like, we know what the problems are today. We know where you're going to get annihilated in the courts. So instead of continuously fighting all of these battles, just you three don't focus on anything else for the next year. Just come up with a plan of what this is going to look like. You three, stop arguing publicly. Start creating what you think this needs to look like on the student athlete side of things. And then once you guys both have a working document, come together, negotiate, figure it out, and see who wants to sign on. I know it's not that easy, but do that. Do that today. Let's stop talking about, we got to wait to see what this court case is. No. You know what the problems are. Go figure out how to solve them, and then come together and agree that this is the best pathway forward for college athletics.
I think there's a lot of merit to that. I really do. But the structure of college sports right now, the way that the governance structure of college sports is, there are too many people who have the power. There are too many people in power who have no desire to give up that power. And collective bargaining requires giving up a lot of power, especially given the leverage dynamics that we touched on earlier in this episode. There's a lot of power that has to be given up in order to make collective bargaining happen. Really on both sides, honestly, because the players have a lot of power through filing antitrust lawsuits right now. And that's really difficult to do. And that says nothing about all of the state law complications of public employee bargaining.
And a lot of billable hours.
That's also
true. You got to
true.
factor that in when it comes to all these lawsuits, Joe. So far, we're 3 episodes in. We've talked Board of Regents. We've talked O'Bannon. We're now through Alston to modern day. And that is just the tip of the iceberg for all the chaos that is NIL and NCAA. We'll get to all of that in the future, antitrust and everything in between. But for anyone that wants to hear from Sam specifically, you probably already follow Sam on Twitter. It's at Sam C. Ehrlich, Ehrlich spelled Ehrlich. Give Sam a question. We'll add it to the next show. We appreciate you for watching, and we'll see you next time on Unilateral Decisions.